Hi, this is Melva Tate, your human capital strategist with Tate and Associates, and wanted to share a few things with you about key HR legal issues and laws. As you already know, the world of HR can be pretty complicated, along with the alphabet soup of acronyms that we have to deal with in managing our workforces. So this presentation will just cover a number of the key laws and regulations that you have to abide by. And again, this is going to be based on the size of your organization and your industry. So again, it's good information to know, although all of the laws and the regulations may not apply to you at this time based on the size of your organization. So let's begin. The first set of laws that I want to talk about are what we consider the discrimination laws, those things that prohibit any type of discrimination against your employees or potential employees. The first one would be the ADEA, which is the Age Discrimination and Employment Act. And of course, it clearly states that it prohibits discrimination against employees or applicants over the age of 40. So age 40 or older, the ADEA would apply in certain cases where there's deemed to be possible discrimination because of age. And then there's the ADA, and then we also have the ADAA, but we'll talk about the ADA, which is the main one that we reference, which is the Americans with Disabilities Act. And this act prohibits employment discrimination based on qualified disability or disabled employees and applicants, and those individuals who may require a reasonable accommodation to do their job based on a disability. So ADA, which is another big one. We hear more about ADA more recently than we have in the past. And that is, again, for individuals with a disability. The big one, Title VII, we talk about it quite frequently. That's the Civil Rights Act of 1964. It prohibits discrimination in employment based on race, color, religion, national origin, or sex. So Title VII prohibits discrimination in any term, a condition of employment or privilege of employment, the process of employment, hiring, the application phase. All of those things go into Title VII. It also prohibits sexual, racial, religious, and ethnic harassment in the workplace. So really, the Civil Rights Act of 1964, Title VII, as we call it, becomes a catch-all for most issues of discrimination that take place in our workplaces. The PDA, which is the Pregnancy Discrimination Act, of course, it is exactly what it says. It's an amendment to Title VII, and it prohibits discrimination against pregnant employees or employees who may be pregnant and applying for a job. So applicants who are pregnant or employees who are pregnant being treated differently. So those are the core discrimination laws that we have in place, or acts that we have in place. And then if you look at the Family, Medical, or any type of military leave, FMLA, which is the Family and Medical Leave Act, that is an act that allows the employee time off for a serious medical condition to take care of family members. So you get up to 12 weeks of unpaid leave. During that 12-month period, you have to be employed for at least a year or 2,080 hours. And certainly one of the amendments that was made to FMLA was up to 26 weeks is allowed for families of service members. So the reentry piece was added to it to again allow those family members to rebond, or an individual to take care of a military family member for a related injury. And then you have the Uniform Service Employment and Reemployment Act, and it is the act that protects the jobs of employees called up for military service. So again, we see reservists who fall under this, individuals who go into active duty fall under this Employment Rights Act as well. Our healthcare benefits. So we already talked about 3 of them thus far: FMLA, PDA, which is the pregnancy, and the USERRA, which is again around the military leave. But we also have COBRA. So that's the long one, Consolidated Omnibus Budget Reconciliation Act. We just call it COBRA because nobody pronounced that long name. But that is the continuation of group health coverage when an employee leaves that job, or a family member would otherwise lose their coverage And again, that's because the individual who was the primary on the coverage left their employment if it was death, divorce, or other life events. So COBRA is a benefit that will provide the health care coverage for individuals after separation of employment for whatever reason. And then HIPAA, HIPAA, which is the Health Insurance Portability and Accountability Act. And this is one that helps smooth the transition from one healthcare plan to another, making it easier for employees to obtain health insurance when they change employers. And it also helps protect medical information. And then the laws for hiring, firing, and discipline. Again, you see the ADA, ADEA, Title VII, PDA, and then the Immigration Reform and Control Act, which is what we call the IRCA, and that is one that prohibits the hiring of illegal aliens. So if you are around someone that they talk about doing E-Verify or an I-9 form, that is what that last one is about, the IRCA, and that is ensuring that we only hire individuals who are eligible to work in the U.S. or if they're authorized through some type of visa, HB1 visa, then that information is notated on that I-9 document. So for pay, there are some rules and regulations that go into ensuring that individuals are paid fairly. One of them is the Equal Pay Act, and it requires employers to pay women and men the same wage for performing the same type of work. So not down to the penny. There can be some variances, but this prohibits big pay disparities between men and women. If a study is conducted and you see that all of the women in a particular group, so if you have 50 people doing the same type of work and you have 30 men and 20 women, and if you look at a study and all 20 women are the 20 lowest paid individuals, then that would indicate a problem with Equal Pay Act. But again, it's not penny for penny, and certainly we can dive deeper into what that means. You got the Fair Labor Standards Act, which is FLSA. That has been a hot button issue more recently with the increase of the exemption threshold for administrative salaried employees. But FLSA, or the Fair Labor Standards Act, also covers overtime wages and then also minimum wages as well. And then the other thing that it would cover, particularly based on your industry, is the federal child labor laws. So FLSA through the Department of Labor is a huge, huge act that requires a lot of time and attention when it comes into paying your employees and paying them properly. Retirement benefits, ERISA, the Employee Retirement Income Securities Act. And this one regulates employee pensions and retirement funds. Again, this was put in place to ensure that organizations, companies were not ripping off their employees from their pension and retirement funds. I will say this and just stick a pin here. Most of these acts and regulations did not come about until somebody did something wrong. So you have a whole case of individuals not necessarily treating their employees fairly. Complaints were made to the government and they reviewed it, looked into it, conducted investigations, found out that it was just not one employee. It appeared to be a systemic problem throughout the workplace. Not everybody, but some. And it required the government to put in some acts to protect their employees. So all of these things, if you think about them, why the need for FMLA, why the need for equal pay, is because someone came along before us in a leadership role and did things improperly or incorrectly as it relates to their employees. Therefore, we have HR issues and laws and acts that we must follow as an organization. And then safety. So you have the Occupational Safety and Health Act, which we call OSHA, OSHA, and that is the act that requires employers to provide a workplace free of recognized hazards that may cause serious injury. And then the law has given rise to numerous specific standards that regulate particular safety and health issues. So whether that's hazardous communication training, so you know exactly what type of chemicals are used in your work environment, all the way up to reporting accidents, in conjunction with workers' comp and receiving treatment for those accidents. OSHA plays a huge part in ensuring that our workplaces remain as safe as possible. And then the last one, we'll just talk about working conditions, grievances, and unions. And of course, some of you who've been around know that the NLRA or NLRB, the National Labor Relations Board, and in conjunction with the National Labor Relations Act, is one that regulates employee-union relations and prohibits employers from interfering in employees' union activities. So whether that's a union that's already in place, whether that's an organization whose employees would like to unionize and develop a union or bring in a union. But the NRLB is not just for union organizations. There's some regulations that apply to all organizations across the board. And more recently, the National Labor Relations Board has been very, very aggressive in their freedom of speech around employees using social media. So what can employees say on social media, and are those statements that they are making protected? So again, it does not mean that you have a union in place or your employees are trying to unionize. Then this act also covers non-union organizations as well. So those are my key HR legal issues and laws that I thought, and acts that I thought you should be brought up to speed about. They were courtesy of the BLR. And I would suggest to you as you move forward to learn more about key HR laws. So you need to look at your organization, look at your size, find out exactly what you're required to do based on the numbers of employees that you have. And again, ensure that the laws apply to your organization based on your size. There may be some other state laws that apply that may run in conjunction with the federal law, so you need to be aware of that as well. I would also suggest that you review your internal policies and procedures because, again, some of them may go above and beyond what the federal regulation may require. So you need to be very aware. Again, if you look at a policy like FMLA, the Family Medical Leave Act, there are some things that the company can do differently to ensure that they're applying with the act. So one of them could be running your 12 months of 12 weeks within a 12-month period. You can run that on a calendar year, or you can run that concurrently. So from the time that last situation happened, then you start running the clock there versus resetting every January or every September or October, whenever your fiscal year starts. And then last but not least, if you have some concerns with your employees right now, any hot button issues or concerns that you're dealing with, I would suggest that you get with your HR team and make sure that they're fully aware of an issue that you may have with your employees, and you want to make sure that you're doing things the right way. Not only to ensure that you're serving the employee the right way, who's a member of your team, and helping further your mission, but then also you're reducing the risk to the organization by being in your role as a leader, someone in authority, to ensure that you're protecting the company as well. So that's all I've got to share with you right now. I will accept some applause. I hope that you have enjoyed this little snippet of key HR laws and issues that you need to be aware of. And I welcome any questions or concerns that you have to clarify any of the information that was shared. And here's my contact information. So it's very easy to email me, melva@tateassociatesllc.com, or call me 205-223-8612. And by the way, I will invite you to connect with me on all the social media platforms at The Career Coach. Have a good one.